Dear viewers, the lesson of today is natural law modern theories. The idea that law consists of rules in accordance with reason and nature has formed the basis of a variety of natural law theories ranging from classical times to the present. The central notion is that there exist objective moral principles which depend on the essential nature of the universe and which can be discovered by natural reason, and that ordinary human law is only true law in so far as it conforms to these principles. These principles of justice and morality constitute the natural law. A human law which is contrary to the principles of natural law is not really law at all. Thus, the concept of natural law has been used as a touchstone to decide the validity of positive law. Due to the rise of legal positivism, 19th century was a dark period to natural law thinking. However, 20th century has witnessed a revival of natural law philosophy. Stamler, Kohler, Radbrush, Finnis and Fuller are the chief exponents of natural law theories during 20th century. In this lesson, it is planned to discuss their contribution to natural law theory. Fall of natural law theory in 19th century. Two principal developments were responsible for the decline of natural law philosophy in 19th century. They are the rise of legal positivism and non-cognitivism in ethics. In legal theory, the overall hegemony of natural law had been overshadowed by Montesquieu's Esprit des lois. He emphasized that the efficacy of a law must be tested by its effects in societies. He conceived law to represent the relations of men in a society and therefore influenced by the circumstances and conditions of the society, such as climate, soil, environment, religion, occupation, customs, commerce, riches of the people, etc. It was David Hume in his Treatise of Human Nature gave a decisive blow to the natural law philosophy, which was based on the faculty of reason in man. According to Hume, reason cannot dictate a course of action. He conceived the moral sense as the force that induces right conduct. Law is to prescribe right conduct. Law must therefore be the formulation of moral sense. According to Hume, the moral sense is determined by popular pleasure and pain. That action is moral which causes pleasure in others, that action is immoral which causes pain in others. This conception of moral sense is linked not with justice, but on popular approval. It upholds public interest. In the 19th century, the popularity of natural law theories suffered a decline. The historical and analytical approaches to the study of law were more realistic and attracted the jurists. 19th century legal thinking gave prominence to certainty in law. The scientific outlook that dominated the era turned the attention to analytical positivism. In the changed climate of thought, it became difficult for natural law theories to survive. The roots of natural law lay in precepts like morality, justice, reason, etc., which the positivists denounced as being unreal, unhistorical, and non-scientific. The dominance of analytical positivism had completely divested law from morality and justice, thus destroying the very foundation of the natural law. It is quite true that utilitarianism and positivism had a powerful force in England during 19th century. Thus, 19th century was, in general, hostile to the natural law theories. However, towards the end of the 19th century, a revival of natural law theory took place. Revival of natural law theory in 20th century. Towards the end of 19th century and the beginning of the 20th century, there was a trend of the revival of natural law theories. A number of factors have contributed to a reawakening of natural law theory in 20th century. The following factors seem to constitute the major landmarks in this evolution. The post-war recognition of human rights and their expression in declarations such as the Charter of the United Nations, the Universal Declaration of Human Rights, the European Convention on Human Rights, the Delhi Declaration on the Rule of Law, etc. Natural law is conceived of not as a higher law in the constitutional sense of invalidating ordinary law, but as a yardstick against which to measure positive law. Thus, the Universal Declaration of Human Rights speaks of its terms merely as a common standard of achievement, or in the French text, a common deal to be achieved. The disastrous consequences of the two world wars resulted in a search for an ideal of justice. The impact of the Nuremberg trials, which established the principle that certain acts constituted crimes against humanity, regardless of the fact that they did not offend against specific provisions of the positive law. The judges in these trials did not appeal explicitly to natural law theory, but their judgments represent an important recognition of the principle that the law is not necessarily the sole determinant of what is right. The Neo-Kantianism of Rudolf Stammler and Dale Vicchio, who developed the idea of natural law with a variable content, and Gustav Radbruch, who until the horrors of the Nazi regime was a legal positivist and then advanced the argument that the idea of law can be nothing but the achievement of justice, which, like virtue, truth and beauty, as an absolute one. Radbruch thoughts are discussed by Professors Hart and Fuller in the so-called Hart-Fuller debate. The Neo-Thomism, now best known to English-speaking lawyers in the works of John Finnis. Finnis' Natural Law and Natural Rights constitutes a major restatement of classical natural law theory, that is, unique in its application of analytical jurisprudence to a body of doctrine usually considered to be its opposite. The development of constitutional safeguards for human or civil rights in various jurisdictions. For example, the American Bill of Rights and its interpretation by the United States Supreme Court, especially the Warren Court in the 1950s. The West German Basic Law. The natural law theory of Lon Fuller and Hart's minimum content of natural law paved the way for revival of natural law theory in 20th century. The reaction against 19th century legal theories, which had exaggerated the importance of positive law. The pure positivistic approach failed to solve the problems created by the new social conditions. Too much insistence on positivism, devoid of ideal and moral elements, made it barren and soulless, leading to conflicts. Dissatisfaction with the command theory of law, as given by Austin, which has banished morality from its fold. Therefore, desire to re-establish closer relation between law and morality. Both the historical and analytical approaches to law proved disastrous to the cause of justice, liberty, freedom, and democracy. The need for a juristic basis for a progressive interpretation of positive law in those cases in which law could not be strictly applied. Lawyers began to feel that law was not simply a matter of applying statutes and precedents to any given case or situation by means of pure logic. The unsolved problems demanded a guide higher than positive law. The development of sociological theories as a reaction to positive law. Expansion in governmental activities coupled with encroachment of individual liberties. Perpetuation of economic disparities within and among societies gave rise to acute social and economic problems which required urgent solutions. The emergence of ideologies such as fascism and Marxism caused the development of counter-ideologies which contributed to revival of natural law theories. The development of idea of relativity in modern jurisprudence, which means that laws are universal and vary in their content with time and place. The new theories of natural law took into account the various approaches to law such as analytical, historical and sociological approaches. There was a search for ideals of justice which resulted in the revival of natural law theories. With the dawn of the 20th century, a reaction set in and the search for an ideal justice commenced again. This time it is recognized that natural law can supply only a framework of principles, and it must be left to the positive laws to supply the flesh and blood to the legal system. Stamler, Kohler, Diehl-Vicio, Radbrush, Finnis, Hart and Fuller hold important place among the philosophers who supported natural law theory in the 20th century. Rudolf Stamler. Stamler, a German jurist, was concerned with the formulation of a right law based upon justice. In his theory of justice, he argues that each era requires its own right law, which should coexist with its positive law. The rules of the community's positive law should be evaluated so as to justify their use by reference to standards derived from the prevalent ethical and philosophical doctrines, and a law found to be deficient would be corrected by the courts or the legislature. Stamler was an exponent of natural law with a variable content. He says that all positive law is an attempt at just law, and what is just law or justice is a harmony of wills or purposes within the framework of the social life. He says law is valid even if it does not conform to this just, but attempt should be made to bring it near its aim. This concept has been called by Stamler as natural law with a variable content. Stamler distinguished between technical legal science, which concerns a given legal system, and theoretical legal science, which concerns rules giving effect to fundamental principles. The former deals with the content of law and the latter relates them to ultimate principles. In this way, Stamler distinguished between the concept of law and the idea of law or justice. The essence of Stamler's jurisprudential thought. It is not the law of nature, but the nature of law which is common to mankind everywhere. Rules within a community must be right for that community because of its unique features. Those rules require testing, but the test must not be a reflection of mere relativism. The aim of the natural law is harmony within society, enabling man to live in dignity, justice, according to truth. Law related to the specific needs of society at a given stage of development will assist man in realizing the purpose of natural law. Joseph Kohler. Kohler says that legal interpretation should not be materialistic. The society in the course of evolution advances morally and culturally as well. Taking the requirements of culture into consideration, law can serve its purpose better. Viewing the things in this light would enable one to know the true aim of law. Kohler is convinced of Stamler's theory of natural law with variable content. He says there is no eternal law. The law that is suitable for one period is not so for another period. We can only strive every culture with its corresponding system of law. The approaches of both Stamler and Kohler are very scientific and logical and free from the rigid and a priori principles. Gustav Radbruch. Gustav Radbruch, a German jurist and philosopher, is the principal exponent of the revival of natural law doctrines in the post-war Germany. Radbruch was a witness to the collapse of the Weimar Republic in 1933 and Hitler coming to power. Hitler's Nazi regime embarked on committing atrocities against individuals, racial groups like Jews, on an unprecedented scale, depriving them of their life, liberty, property, freedom and dignity. The World War II also witnessed crimes against humanity, crimes against peace and war crimes perpetrated by Nazi Germans in complete violation of law, justice and moral values and principles, finally culminating in the Nuremberg trial 1946 for the punishment of Nazi war leaders. As a reaction against the horrors of Nazi regime, Gustav Radbruch expounded the doctrine of higher law to demonstrate that all the Nazi acts were contrary to all canons of natural law. Radbruch declared that a general acceptance of positivistic philosophy in the pre-Nazi Germany made smoother the route to dictatorship. In the post-war period, he enunciates the doctrine of higher law and inner morality of law to demonstrate that outrageous Nazi laws were not laws as they were oblivious to the moral and natural justice. He declared the right of the citizens to disobey such positive laws if they are contrary to ultimate rules of justice. In 5 minutes of legal philosophy, a succinct account of his beliefs, he indicates a move in the direction of natural law. His views are set out in that work in the form of 5 theses. The teaching of positivistic theory equating the law with power render the jurist and other members of the community defenseless against laws, however arbitrary, cruel or criminal they may be. It has been said that law is what benefits the people, but this is incorrect. Only what is law benefits the people. If laws consciously deny the will to justice, and justice involves judging without regard to the person and treating all according to the same standard, then they lack validity. The people owe them no obedience, and even jurists must find the courage to deny their legal character. There can be laws that are so unjust, so socially detrimental, that their very character as laws must be denied. There are principles of law stronger than any statute. A law which is in conflict with these principles has no validity. We may refer to these principles as the natural law or the law of reason. Lon L. Fuller. Professor Lon L. Fuller is a renowned jurist of natural law in the 20th century. Fuller makes attempt to argue against the separation of law and morals. In his The Morality of Law, he expounded the nature of morality and the theory of law and the relation between law and morality. Fuller gives a detailed exposition of the morality, which must characterize an acceptable legal system. It is important to note that in spite of Fuller's concern for morality, he does not personally accept all the doctrines associated with classical natural law. He rejects the Christian approach to natural law, does not accept concepts of absolute values and natural rights, and places no value on the religious interpretation of nature as the grand legislator. According to Fuller, law or legal system is not to be studied as a data or a natural fact. It is rather an activity that is the product of sustained purposive effort. He regards law as a purposive system, and its particular purpose being that subjecting human conduct to the control and guidance of legal rules. To him, law is the enterprise of subjecting human conduct to the governance of rules. According to Fuller, law has external and internal morality. External morality is a morality of aspirations and ideals. Fuller makes distinction between morality of duty and morality of aspiration. According to him, morality of duty embodies the most obvious demands of social living, which means basic requirements of social living. Whereas, morality of aspiration is the morality of good life, of excellence, of fullest realization of human powers. The inner morality of law. Inner morality comprising of irreducible minimum requirements with which a law has to comply. He lays down 8 requirements of inner morality of law which legal system must comply if it is to succeed as law. Conversely speaking, Fuller illustrates 8 ways to fail to make law. These 8 principles are not conceived as maxims of substantive natural law. They are instead seen as a kind of procedural version of natural law. They are: there must be rules. The rules must be published. Rules must be given prospective operation. Rules must be understandable. Rules must not be contradictory. Rules must not require conduct that is impossible. The rules must not be changed frequently. There must be congruence between the rules declared and their actual application. These 8 conditions constituting inner morality of law are procedural version of natural law. The 8 qualities which, according to Fuller, must be present in a legal system if it is to deserve to command allegiance from citizens are discussed as follows. Laws must be in existence, which means there must be rules and they must not exist merely as ad hoc settlements of disputes. Laws must be promulgated publicly, which means the rules must be published and they must be made known to the persons who will be bound by them. Laws must not be retroactive, which means they must not affect adversely persons who relied upon the law as it was. Laws must be understandable, which means they must be intelligible and clear. Laws must be free from contradictions, which means they must be free from inconsistency. Laws must be relatively stable, which means they must not be changed frequently so that the subjects can orient their actions accordingly. Laws must not require the impossible, which means they must not require conduct beyond the powers of affected party. Laws must be administered, which means there must be congruence between the rules as announced and their actual administration. Fuller argues a total failure in any one of these 8 directions does not simply result in a bad system of law. It results in something that is not properly called a legal system at all, except perhaps in the Pickwickian sense, in which a void contract can still be said to be one kind of contract. John Finnis. Finnis, a British lawyer and philosopher, is a Catholic scholar who seeks to investigate the relevance of natural law to contemporary society. In his Natural Law and Natural Rights, he restates aspects of natural law doctrine in novel form. Morality and law are given a rational basis which rests upon two principles. First, there are certain basic values of human existence which are self-evident. They may be secured through the law and its institutions. Secondly, practical reasonableness is required in order to achieve human goods, and this necessitates the existence of an appropriate system of law. The concept of human goods. Finnis set out a catalogue of forms of human flourishing, that is, the requirements of individuals who are to attain their potential. 7 such irreducibly basic goods are enumerated. His list of 7 basic forms of human flourishing are life, knowledge, play, aesthetic experience, sociability or friendship, practical reasonableness, and religion. The concept of practical reasonableness. Finnis classifies under 9 headings the essential features of practical reasonableness. These headings encapsulate principles which seem to be in the spirit of the classical natural law. They are the active pursuit of goods, a coherent plan of life, no arbitrary preference among values, no arbitrary preference among persons, detachment and commitment, the relevance of consequences, efficiency within reason, respect for every basic value in every act, the requirements of the common good, following one's conscience. These constitute the universal and immutable principles of natural law. Finnis argues that this approach accords with the general conception of natural law espoused by Thomas Aquinas. Finnis stands unambiguously within the tradition of the natural law in his consideration of just and unjust laws. For purposes of assessing one's legal obligations in the moral sense, the individual may exercise his right to discount those laws which are unjust. Laws of this type do not possess the moral authority which ought to stem from their origin or formal source. But an unjust law is not a nullity. Finnis interprets the aphorism lex injusta non est lex as suggesting merely that unjust laws, although formally valid, do not meet the demand of the natural law. This lesson is an attempt to examine theories of natural law during 19th and 20th centuries.